Well, welcome everyone. You didn't expect to see me back so soon. Well, welcome to a very special edition of Investment Immigration Conversations, prompted by the extraordinary executive order signed September 19th by President Trump, announcing that the Trump Gold Card is here at last. So this is obviously huge news to the investment immigration community. And so we're going to talk about it a little bit. We're going to talk about what we know and what we don't know, and maybe throw in a little prognostication in there as well. First, just some resources. You can Google the text of the executive order, which was signed on September 19th. 2025, just last week, at the end of last week. And if you just Google it, and it's at the www.whitehouse.gov, Presidential Actions 2025, /09 / the-gold-card. There's also an accompanying video at the press conference, taken at the press conference, where the executive order was signed, which is very interesting. And that is in the videos section of the whitehouse.gov website. And the third source is the trumpcard.gov website, where folks can begin to register and show interest in both the Trump Gold Card and the 5 million Platinum Card. We don't have a lot of information yet on the Platinum Card. The Gold Card was the subject of the executive order, and that's what we'll be talking about today. All right, should we get started? Okay, so what do we know? It's 1 million. It's not 5 million. 5 million is the Platinum. 2 million, there's also a 2 million in here. The 2 million is for companies sponsoring workers, and that 2 million is per worker, though it can be transferred to another worker, presumably at the close of the first worker's assignment. We're going to talk about the 1 million, which is for individuals. So we had a lot of questions when the first mention of the Gold Card came into our lives. And a key question was, well, where would this be slotted? And of course, those of us in the EB-5 space were somewhat concerned that there would be an encroachment into the EB-5 numbers, these precious, too few numbers of less than 10,000. Well, it's clear now that the Gold Card would be situated not in EB-5, but in EB-1 and EB-2. EB-1 is the category reserved for priority workers. EB-2 is the category reserved for exceptional ability individuals and individuals holding an advanced degree. So that question is answered. What about other questions? Well, how would this donation or this gift of 1 million qualify for the existing visa schemes, the requirements under the EB-1 and EB-2 categories? Well, we do have indications of answers to those questions as well. Exceptional ability or extraordinary ability would be conferred, would be deemed to be present for those who meet the test, meet the requirements, to be announced to qualify in the extraordinary ability alien subset of the EB-1 category, the EB-1A. Similarly, by virtue of contribution to business and commerce, and by virtue of making this extraordinary investment into the US government, or rather this gift to the US government, that act might be deemed sufficiently in the national interest, and those individuals' abilities may be sufficiently exceptional to qualify under the EB-2A category for exceptional ability aliens, and also possibly qualify for the national interest waiver under 203(b)(2)(b). So the national interest waiver is the mechanism that allows EB-2 applicants who normally, whether they have an advanced degree or whether they have exceptional ability, to be subject to the labor test of the US labor market to ensure there's no US worker displacement. So the executive order is saying, by virtue of this gift to the US government that would enhance our economy, reduce debt, help defray taxes, that gift might be deemed sufficiently in the national interest. Now, these are broad strokes, obviously. The order itself was just a few pages. So when are we going to know exactly what the requirements will be, what the rules of the game will be, how to begin applying, etc.? The executive order answers that question by instructing the Secretaries of Homeland Security, State, and Commerce to promulgate guidance implementing this executive order within 90 days of the order, which would take us to mid-December, approximately December 18th, 2025. Now, in anticipation of this gateway being opened, there is that third site that I mentioned, which is trumpcard.gov. And it says the Trump Gold Card is here. And there are two areas marked gold and platinum. And the gold section, the gold portal, part of the portal, is for that 1 million gold card program that we're talking about, that is the subject of the September 19th executive order. But intriguingly, there is also a portal and a mini questionnaire, statement of interest area for the platinum card, which says that for $5 million donation, individuals applying in the Platinum Card program would be afforded 270 days in the US without being subject to US taxes on non-US income. There you have it. I think it's interesting to talk a little bit about, before we get into the distinctions between EB-5 and the gold card, there have been some questions and critique of the gold card program, which I think are very important for us as a matter of policy, not so much at the kind of the technical level of understanding how it works and how it will be implemented and how the applications will be processed. Those are all important questions, and we should have answers to those within about 90 days. But there are questions like, and some rather tongue-in-cheek, is this wholesale sale of the green card, of the American dream? And I did ponder on that. And is it? And I think in a sense, perhaps, but it is actually not a sale. And it's important, these distinctions, these somewhat formal distinctions are incredibly meaningful. It is not a sale. This is a gift. So when you have a sale, there is an exchange. You purchase something with consideration and you get something in return. This is a gift, and so there is no quid pro quo, although there is a benefit for the donor providing the gift. So it is a gift, and the United States wouldn't be alone in having a donation program for an immigration benefit. But when we look a little bit deeper into this as well, every single one of our green card categories, aside from the ones that are based on family relationships, are quid pro quo, are about, okay, we will confer upon you the right to live and work in the United States under whatever category, E2, L1, H1B, O1, or in the permanent residency side, EB1, extraordinary ability or priority workers, EB2, advanced degree holders, EB3, skilled workers and professionals, EB5, investors, in exchange for what you are contributing to the country. In the EB5, we know, we talk about this every minute, it's the investment of the required amount of capital, and it must create jobs. Those are the conditions for the immigration benefit conferred, the EB5 green card. The other categories are not dissimilar. Priority workers, you are conferred an extraordinary ability or multinational manager green card because of what you are bringing to the US. You are enhancing the United States by bringing your extraordinary ability in your particular field. Or you're a multinational manager and you are going to work for your affiliate company here in the US in this important executive or managerial business capacity. Or you're going to provide services to companies, and you have an advanced degree, or you're a skilled worker, or you have a professional degree. And those visas are conditioned. They're conditioned on those workers conferring a very specific benefit to the US. So I would say it is transactional, if you want to put it that way. Each of these benefits do not come for free. They are in exchange for some benefit to the United States. So the idea, are we selling, are we somehow degrading the value of US residency? I would say it's quite the opposite, right? I mean, view it in those terms, because it's elevating the value. Because if there is any category where we've set the dollar amount of residency, it's in our EB5, and we've set it at 801.05, and this is setting it at 1,000,005. So maybe there's more to discuss, and I think that there is, in terms of the policy goals. What are the goals of US immigration laws? This is a profound question. Decades ago, it was family unity. It was economic benefit to the US. Maybe in the 2000s, in the new millennium, we need to amend that, add to it, tweak it a bit. But these are the larger questions that we as a society face. Okay. The EB5 versus the gold card. Well, first of all, there is an investment threshold difference, and being involved in legislative discussions and negotiations from 2012, even 50K is meaningful. And so we have here a 200K delta from 800 to 1 million. So this is going to be very meaningful for some. It will simply exclude some individuals from being able to participate in the gold card. So they only have the EB5. EB5 is an investment. The gold card is a gift. So with gifts, there's no expectation of return. With an investment, there is the hope of a return. Not guaranteed ever, always at risk, but there is the hope and expectation of a return. So that is huge. That's a huge difference. Folks will not go into a program like this, whether it's the gold card or the EB5, if there's no expectation of a return. Some will, for sure, but those folks are most appropriate to go into the gold card line. Those who need and who have a strong expectation, a desire for the return of capital at some point, the EB-5 is really the only route. In terms of requirements, job creation, right? In addition to the investment, it's EB-5 requires job creation. That has to be a part of the benefit application. We don't have the details of what will be required for the gold card, but the job creation requirement is likely not to be an explicit part of the requirement. What about the lawful source of funds? So in EB-5, of course, this is essential to document, to trace, to provide extensive evidence that the investment proceeds derive from lawful sources. What about for the gold card or the platinum card for that matter? Well, there is language that says, first of all, every single individual will need to meet the admissibility requirements of our INA, but also there is mention of vetting. And I think that could go either way. It could mean that the vetting is a la lawful source of funds analysis, okay, intense, or it could mean something other. This is very, very important, obviously, and we'll be listening very, very, very carefully for that. Another important distinction is the visa pool that these benefits are drawing from. In EB-5, we have fewer than 10,000. It's 9,980 in a normal year, unless we have fall across, right? Well, for the gold card, currently slotted in EB-1 and EB-2, the potential pool is 80,000. There's 40,000 in EB-1 and 40,000 in EB-2. So together, there's 80. So this is a much, much larger pool. There's expedited. That's another distinction. Expedited is the word used in the executive order path to permanent residency via the gold card. In EB-5, we don't have an expedited route as such. We have prioritized processing for rural petitions that we are most certainly for sure seeing. We do not have an expedited track. We don't have premium processing. So it remains to be seen how this expedited process will be implemented. Very important, and we'll be looking very closely for that. The other related question is, well, what about the fact that we already have backlogs in the EB-1 and EB-2 categories? So how is this expedited feature going to be implemented? Now, that is another structurally interesting question. And this is just speculation on my part. There are mechanisms. For example, we've seen in the EB-5 category, we had a very long backlog in EB-5 pre-RIA, post-RIA. We have categories that are current and remain current to this moment. How did that happen? By the creation of set-aside categories, subcategories within the preference category. So that could very well be implemented to enable the expedited processing. Can this all happen by executive action or within the purview of the cabinets? Doesn't this require statutory change? I'm not sure it does. Not within the framework presented, because now we are in existing visa categories of EB-1 and EB-2. And so could these other structural adjustments be made within those categories? Very possibly, because remember, one of the arguments that we are making in the EB-5 space is that the way in which the State Department counts the visas can be changed. This is a matter of State Department interpretation that the executive can recast, can instruct that a different interpretation be adopted. So there's quite a bit of authority within the executive, within the operation of the cabinet departments, including the Department of Homeland Security, State, and now Commerce. So those are some reflections just 2 days after the passage of the signing of the executive order on September 19th. So do please stay tuned. We will be reporting and discussing and looking very closely, keeping our ear to the ground on any clues, on anything published, made public. So stay tuned. It is going to be a very, very interesting last quarter of calendar 2025.